Hey everyone, it's Rob Ryder. What is it today? Today's Wednesday, March 7th, 2018. And today, official business in the United States. USPS delivered. Federal Question Jurisdiction acknowledged. Case opened. United States District Court. Magistrate judge assigned. Total cost to the informant, $6.70 plus a one Forever Postage Stamp. So hey, let the games begin. Let's see if we can convert a civil action now to a penal/criminal action, which was the intention in the first place, was to ask for arrest warrants. But all that I've just said means is that by using priority mail, a complaint was sent to the United States District Court, and a court case has been opened. But the lady that sent the mail didn't go to pay to have the court case opened. This is at the federal court now, right? What is it, $470? Something like that, people think, to open a court case? She didn't do that. She didn't do the $46 miscellaneous, which is the other option they have on their websites. She didn't do that. She sent a complaint, and somebody else opened up a court case. Well, I believe the only entity that can open a case without paying is the government. And at the end of the day, there's a court case. So let's see what that's all about. We'll look at what she put in and what it shows on Pacer. And another lady that I've done it with now, and she's put hers in. She actually did hers first, but because she added a few too many documents to make it easy to go through, I really can't show you all that one, but this other one's quite simple. And I've tried to send one to the Supreme Court, waiting to see how that goes. I don't know how much of this we're going to be able to cover in one video. It's a lot of information, but we'll just start with the basics, right? So, I'm not going to tell you how to do this in this video, and you're not going to call me and ask me how to do it, because I'm not ready to tell you. I don't really know. I'm figuring it out. Right? I don't have an answer for you. What I'm trying to do is try things to see what happens, and based on that, go try something else, right? To be a doer, not a talker. And so this is just doing, and we're in the middle of doing, and we don't have an answer yet. But I can tell you for $6.70 and a Forever Postage Stamp, a lady has a federal court case now where she's the plaintiff. She's not the defendant. Well, I want to make her the XRL plaintiff and make the United States the plaintiff, right? And have the United States prosecute and get her a remedy for bringing the offense against the United States to the attention of the government. And that was the idea of doing the official business mail, because official business is done by official mail, and they've been hiding from us how to do official mail. For us, official mail is prepaid postage. But when you go down and put a first-class letter in to the post office, what you believe to be a first-class letter, they're not canceling the stamp properly, so it's not prepaid. It's not being sent in the mail, it's being sent out of the mail. And we need it sent in the mail. That's the protective cover, right? The mail isn't the letter or the information. The mail is the thing protecting the information. In this case, it's a priority mail package. Before we go there, though, hey, if you can, please donate. I help keep the lights on. My PayPal account's robryder@aol.com. Snail mail to myself. Walmart, Western Union, and then send me an email, tells me what I need to do to go pick it up. Now, my email address is courtofrecord@aol.com. It really isn't robryder@aol.com. That's my PayPal account address. If you want to talk to me or contact me, it's courtofrecord@aol.com. And if you leave a message on the videos, right, I don't read them. So if you leave a comment, I don't read the comments. If you want to talk to me, want me to see something, you need to email me. I'll do my best to pay attention to it then, but I don't pay any attention to the comments. Okay, so what the heck happened? Well, let's just start with what we have here. Okay, in my last video, one of my last videos, was on official business by official mail, I think was the name. I showed this envelope I had that says official business on it, and it has a return address above it. And based on research, I came up with, hey, if it has that, if it says official business on the envelope, then the address, return address, has to be the proper address. Okay, well, I want to do official business. I need to send it then to the office of the clerk, United States District Court. Right, this right here. And then this 399 Federal Building, 110 Michigan Northwest, Grand Rapids, Michigan. That's going to change depending on what courthouse you're going to. Right? But the office stays the same. Office of the Clerk, United States District Court. Now, it doesn't say Western District of Michigan, although that's the court that mailed this to me, right? That's where you think Grand Rapids, Michigan is. Well, that's the Western District of Michigan. Federal court. No, it's the United States District Court. I don't want the Western District of Michigan. I don't want the subdivision. I want the, to me, the United States District Court is when the United States is just one district and it has one court. That's really the Supreme Court. But anyways, so using this idea, I had a couple of different people that had situations going on. So well, let's just mail it here and we'll see if we can make it an offense against the United States and get them to issue an arrest warrant. And so let's just do the easy one first. So just this week, mailed one day, delivered the next, court case the same day. Right? Mailed Monday, court case on Tuesday of this week. This is Wednesday. I'm talking about it. So Helena put an envelope addressed, as you see it here, Office of the Clerk, United States District Court, right? Hers is Alfred A., whatever it is, courthouse in Denver, Colorado. So you go to your federal court website, the court building you believe that you would go to, and that's where you get all this information about the physical address, right, of the court. But the office you're going to be writing to is the Office of the Clerk, United States District Court. With her information up here, official business, United States, underneath the thing, right? Name, street address, city, state, zip, 5-digit zip, United States. Official business, United States, right? That's how you would do it. That's why I believe you need to do it. If you think you need to do it a different way, go ahead. Don't ask me about it. Just do as you're told or do it your way. But I believe that's the proper way to do it. And on the envelope, put postage and fees. Postage and fees paid. First class mail. Address the envelope. Office of the Clerk, United States District Court, with the physical address with the United States under it. Because we want this to be domestic. It went from the United States. It's going to the United States. This has nothing to do with non-domestic. This is all domestic in the United States. First class mail, right? And this is an envelope. So whatever you do, you put in the envelope. And then you put the envelope in a priority mailer. Now she looks to me like she used the one that's the size of a, maybe not, just have it turned sideways. All right? Flat rick envelope. On that side and on the back, right? From, to, again, just like she did on the envelope, official business, United States. United States, put it on there. $6.70 U.S. postage paid. And when you read the way you're supposed to do this, because priority mail is actually for packages, not first-class letters. If you're going to send a first-class mail, you need to put first-class mail enclosed on the form. And it says to do it between the postage and the delivery address. We'll look at where all this came from, right? I'm just trying to show the paper right now. This is as simple as it was. It cost $6.70. And because we're going to put a first-class letter in here that doesn't have a stamp on it, it says postage has been paid, right? Or the envelope does. Then we're going to put the stamp on here. And on the one I did it, I put it like in this spot right here, right? Now, I did mine from home. I did the click and ship with priority mail. So I made up my own label, didn't have to go to the post office. They came to my door and picked it up. Delivered it to the Supreme Court's courthouse. The problem I'm having right now is you can't quite search the Supreme Court's site the same as you can these other sites on Pacer. I haven't really spent much time on Pacer, so I'm kind of learning it as I go. But I was able to find this case on Pacer. All right, so this is what the court did now. The court made copies of her envelope. Right? So if you've ever done a federal court case before, did they make a copy of your envelope or anybody's envelope? There's the case, 118 CV 00586 GPG, file 3618 USDC, Colorado. These are all different, slightly different than the ways I've seen federal documents called before. And I'll show you better in just a second, because right now we're just looking at the envelope. I was kind of amazed that they had actually copied the envelope, but they did. Okay, now what was in the envelope? Well, before we read it, there's the case number. It was filed, USDC, Colorado, page 1 of 4. It's a 4-page thing. Postage and fees paid. Hey, we did that just like we had done the envelope. This is the interesting thing, though. Filed, United States District Court, Denver, Colorado. Well, that's not the same way that they do other stamps. So as a for instance, right? So now we'll look at another case. This was in Kentucky. I just had to go find one to see, what was different about the way they were doing the citation of the case and so forth. All right, but here's this one. Now, it's a criminal one. In fact, I did a video on Sam Gerard. That's the Amish guy they put in jail for making salve or something like that. Right up here, it doesn't say anything about United States District Court like this one did. Well, this one did. USDC, right? There is no USDC up here. This is filed in the Eastern District of Kentucky at Lexington. This is filed in the United States District Court, Denver, Colorado. I believe that they're different. What would you say? Right? It's gone into a different office. It's gone into a different hat. Or the same people wearing a different hat. Let's put it that way. Right? Now we're getting them into, as this will show, into a thing called federal subject jurisdiction. And technically, then, we've put the district court into its Article 3 hat. So what did this say? All this was really the same as what was on the letter, right? Except I had put her Social Security number. Take advantage of it. It's your property. Say it's yours, right? Using her full legal name. So clerk, take notice. I'm informing you of offenses against the United States requiring arrest warrants issued, and that the government of the United States provide equitable relief. I'm the victim of a simulated legal process ongoing within the Federal District of Colorado that makes the United States a party to the controversy and invokes the District Court's Federal Question Jurisdiction. By use of false statements and omission of material facts, individuals who falsely assume or pretend to act under the authority of the United States are simulating a legal process under color of law in an improper venue before a private tribunal that has no constitutional authority to adjudicate legal matters involving the people of the United States. Their scheme is to extort and embezzle my property, including the value of my one share of the public trust now held under Social Security number. I have enclosed a recent illegitimate filing marked as Exhibit 1, filed with the clerk of a non-existent court under case number 16 CV 31937, upon which the numerous false statements and omission of material facts are self-evident, such as, okay, so before we go through the 1, 2, 3, 4, here's the piece of paper I put in. Now, I would have preferred to put in the summons and complaint, the very first piece of paper that they would send you, because this should work for any kind of court case. Pay attention to what I'm saying. You don't need to call me on this shit. You just need to think about it and do it. Right? If you've been called to court for foreclosure or whatever, right? Look at the damn piece of paper, the summons and complaint, and find the errors. It'll be on the very first piece of paper. You won't have to go very far. It'll be right there, right? Because in this case, the district court, Jefferson County, Colorado, well, that's not the proper name of a court. It's like the first judicial district or something like that. Right? So that's not the proper name of a state court. The plaintiff, Snowbird Phase 2 Condominiums Association, Inc., a Colorado nonprofit corporation, is an unregistered legal fiction. It's not the name of any entity registered with the state of Colorado to do business in the state. The defendants, nobody is in their full legal name. If you're not in your full legal name, it can't be a legal matter, as long as you say so. All right, what's your full legal name? Congress has defined the full legal name in 6 CFR 37.3 as your first name, middle name, last name, suffixes, no initials, no nicknames. 6 CFR 37.3. Go look it up. Right? Got a middle initial? It ain't a legal name. Period. Attorney for plaintiff. Well, look at that. He's using the middle name. Guess what? There is no attorney licensed to practice, and yes, you have to have a license to practice in Colorado. And he ain't got one. And, well, that just says that right here. This is Title 12, Article 5 of Colorado statutes. License to practice necessary. No person shall be permitted to practice as an attorney or counselor of law, or to commence, conduct, or defend any action, suit, or plaint in which he is not a party concerned in any court of record within the state, either by using or subscribing his own name or the names of any other person without having previously obtained a license for that purpose from the Supreme Court. Okay, so you could read the rest of it, but the part I wanted to get to is the clerk of the Supreme Court keeps roll of attorneys. It's the duty of the clerk of the Supreme Court to keep a roll or record of persons who have been regularly licensed and admitted to practice as attorneys and counselors at law within this state and who have taken the prescribed oath. Now, anybody can be an attorney. I can be your attorney. Give me power of attorney, I'm your attorney. I can sign for you. It's the counselor at law that requires the license. And so when these people go through law school, they're attorneys and counselors at law, not just attorneys. It's attorney and counselor at law. It's it's an office. And counselors need to have a license. And so the question is then, on that roll of attorneys, where the heck is it? On that roll of attorneys, what were we looking at? This? Yes, right. Is there anybody with Richard W. Johnston? If not, well, then he's not authorized to practice in Colorado. So, there is no state of Colorado court named District Court, Jefferson County, Colorado. Case 16 CV 31937 is prosecuted in an improper venue. The judicial officers of this court have no authority under the Constitution. They have not been properly appointed or elected to adjudicate the law in Colorado. Right? The people sitting there as judges in your state, they don't have a proper oath of office. They don't have the oath of office required by the state constitution. They don't have an official bond. They weren't properly elected. They don't have a certificate of election. They don't have a certificate of appointment. They don't have anything. Right? The state is vacated. I don't know exactly who they are, but they're not the state. Now, they have gold fringe flags in their courtrooms, so they should be enforcing the federal law, but instead they're simulating legal processes. That's why we're taking them to federal court. right? They're not using the name of the court. There is no District Court, Jefferson County, Colorado. If you go look it up and say it's the First Judicial District. Snowbird Phase 2 Condominium Association, Inc. And I should have put the rest of this because really what, right, comma, a Colorado nonprofit corporation. See, they put that in as the name of the plaintiff, right? That is a legal fiction. It's this whole long thing. They made up a thing out of something that could have existed, but they changed it. They do the same thing on your grant deed for your property. If you go look at who the grantee is, and you think it should be you, they made up a legal fiction. They did the same thing with the borrower on the deed of trust, right? The borrower on the deed of trust is not you by name. It's a legal fiction that's never been registered. It's the games they play. And so once you know what the game is, well, they do it all the time. You just need to look. Well, they never do anything right. Attorney for plaintiff is not authorized to practice in Colorado if Richard W. Johnston is not named upon the official roll of attorneys for Colorado. Colorado Revised Statutes, Title 12, Article 5. Individuals listed as defendants are not identified by their full legal name. Helena M. Topa, defendant, is not my full legal name, and its use to identify myself in legal matters is identity theft and unlawful conversion. Congress defined full legal name as part of the Real ID Act in 6 CFR 37.3 as an individual's first name, middle names, last name, or surname without use of initials and nicknames or nicknames. My accusers are not using their full legal name or my full legal name. So there is no way that 2016 CB 31937/16 CB 31937 can be legal. Clerk, I have provided you probable cause of an offense against the United States and demand you take action to suppress the offenders and provide equitable relief and protection from these belligerents. I declare in a penalty of perjury the foregoing to be true and correct. Executed on the 4th. Today's the 7th. On the 6th, you had a court date. Or a court case set. Probably should have put informant behind you. So again, I don't know if I do it exactly the same again, as we'll see as we go through. One thing I would change is this RE. Right? I wouldn't just make it official business of the United States. I'd make it information on offenses against the United States, application for arrest warrants, and equitable relief. Something like that. Because they put that stuff, on into PACER, right? Whatever the RE was. Okay, received United States District Court, Denver, Colorado, March 6, 2018. Now, how does that look? It was received United States District Court, Denver, Colorado. Filed United States District Court, Denver, Colorado, at 2:07 p.m. All right, it's got a time even. This one don't have a time on it. Okay. That cost $6.70 to get a court case. Well, plus a postage stamp. A reason for that, let's cover all these little bases now. We can get them out of the way. Where the hell would that be? Why would I do that? Because of some stuff that I had read, that I had done on my last video. We should look at official mail definitions real quick. Official mail. Official federal government mail includes penalty mail, frank mail, and prepaid mail. Well, penalty mail is what the government uses when they send you something. Or frank mail is when the congressman is supposed to be able to sign their name, although they haven't done that since like 1870s. I wonder why. But penalty mail is when they send it to you and it has that little thing in the right-hand corner where it says, send under some other permit number or something. Federal agencies may use penalty mail via meters, permits, business reply mail, yada, 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 right? Well, the one we want is prepaid mail. Now, somebody asked me where this came from earlier, and it's under USPS, What We Are Doing, Government Services, GOV-services is where you'll find that linked. Okay, and what they were keeping from us is the prepaid mail because they don't cancel stamps at the post office anymore. They don't have black cancel stamps. I was told by a postal inspector, well, they ain't got any black cancel stamps at the post office anymore. I guess it ain't the post office then. That kind of goes along with not having, anybody on the board of the United States Postal Service, where they're supposed to have 9 appointed governors, and those 9 governors will appoint the Postmaster General and Deputy Postmaster General, and those 11 together will be the board, or the Board of Governors. If you go and look, there is no Board of Governors, yet there's supposed to be a Postmaster General and a Deputy Postmaster General sitting on the board. Well, how did they get there if nobody could, if nobody was there to appoint them? So this whole thing with the mail is really screwed up, right? But it doesn't change the fact of what the definition is. If you could figure out how to send prepaid mail, well, then it would be considered official mail. That was the thought. So, well, let's see if we can make that happen. Okay, I got to start closing some of these out. So then, what did we do? Then there was, so then there was this thing called these mixed classes of mail. Right at the beginning, mailers are subject to a fine if they conceal letters or other mail of a higher price in mail sent at a lower price without paying the correct postage on the enclosures. Mailers are subject to fine if they conceal letters, we're going to send a letter, or other mail of a higher price in mail sent at a lower price. Well, that'd be like business mail or standard mail, instead of sending it first class mail. And so business mail is like parcels. And so since we're going to send it in a priority mail packet, which is really first class mail, but it's first class package, not first class letter, well, we need to do a couple things. Again, I'm just basing it on what I read in this 700 special standards, right? That's part of the domestic mail manual. DMM 700 special standards. Okay, letters or other piece of first-class mail may be placed in an envelope and attached to the address side of a periodical. Well, we didn't want to do that. Quite. We want to do something like that. Letters or other pieces of first-class mail may be enclosed in marketing mail, parcel mail, package services. Okay. Postage at the appropriate first-class mail price must be paid for each piece of first-class mail. Okay. So what's the price of first-class mail? Well, that'd be 50 cents. That's for the envelope. Okay, so I'm going to pay that plus the postage to send the package mail. Except incidental first-class mail attached or enclosed under 9.5. So if we could say, well, it's really incidental, which I don't see whether there's any reason we can't, but for 50 cents, I'm going to do it like it says under parcels. The mailer must mark first-class mail enclosed or USPS marketing mail enclosed on each USPS marketing mail parcel select package service parcel. With such an enclosure, the marking must be placed below the postage and above the delivery address using any method that produces legible wording. And okay. Jeepers, Bob. I'll tell you what. Hang on just a second. Okay. So if you do click and ship, right? If you have a business account through the post office, you can order these mailing labels, which are just blank, right? But they're die cut onto the stuff, and you feed them through your printer, and you can print out your own mailing label. And so this is the way I did it, right? And so in between the postage And the delivery address, John Glover Roberts, the Supreme Court, 1 First Street Northeast, Washington, D.C. You're supposed to write in first class mail enclosed. Which, it's kind of what we tried to do. Hey, we're close, right? Put it on there. Hey, our intentions were great. You didn't give us a place to do it. I'm just saying, when you read what it says, this is why I wanted to do mine myself from the house, to put first class mail enclosed right there, and then go ahead and put a stamp on to pay for the letter that's enclosed inside the priority mail pack. Right? Where this cover then is acting as the mail. It's the protector. And because I put 50 cents on there, right, and it's not been canceled yet, I'm going to insure it for 50 cents. And then I think they have to get somebody to sign for it. Because with priority mail, you get insurance up to $100. But, how much insurance did you have? Well, I had 50 cents. I guess I could have put all my postage if I wanted. Right? But this is the postage, $6.70, I think it was, yeah, for just standard priority mail and a postage stamp. Okay, back to this. So, that's what this is, right? The marking must be placed below the postage and above the delivery address using any method that produces legible wording. And really, that's all there was to it. Postage for the first class mail may be paid by affixing the correct amount in pre-canceled or meter stamps to the enclosure or to the outer wrapper. But postage for parcel select packages, service parcel. And so when it says parcel or package, I say, well, that's priority mail. It's package. It's not letter. It's a parcel. Postage for enclosure must be placed on the outside of the parcel, either separately or by addition to the postage for the parcel itself. Now, this says it doesn't have to be canceled, it just says it needs to be on there. So, I did. Right? I did. Put it on there. It's right there. There it is. Hey. Off she went. Okay, I can close that one. And I addressed my letter this way, right? So this envelope was inside of the priority mail. Now, I believe because I've registered my business, right, that when I myself am writing, right, my address is 10955 14 Mile Road Northeast, and it's care of Robert Allen Rutluski, the business, which shares the same address, physical address. Official business, United States. To the Chief Justice, the Supreme Court, 1 First Street, Northeast, Washington, D.C., United States. Now, I'm not sure if that's the official address of the Supreme Court. And now, having thought about it more, well, I need to do a FOIA to the post office, USPS, to find out it from the Appendix A of the official mail manual, which I believe is DMM 103, and it lists in Appendix A all these offices that have permits to send official mail. If they have a permit to send official mail, then they had to supply the proper return address for official mail. And that's the address that we saw in the letter I showed earlier. Right? It's going to be, it'll be up here, say official business under it. Well, that's the address. And so I'm going to try to get it for the Supreme Court. And, there's a bunch of agencies in DMM 103, or maybe it's Handbook 103. It's the official mail handbook 103, right? If you Google that, you should be able to find it. Go to the back, Appendix A, list all these government agencies that have ability to send by permit what would be called penalty mail. And they also have, by permit, the ability to have business reply mail that you could use to reply to them. But I couldn't get anybody to send me a damn envelope. So instead I said, well, I'll just prepay it and see if it'll go that way. And while mine's kind of in limbo because I haven't found it yet, it worked for these other two ladies just fine. So, okay. And by doing it, it didn't go to Eastern District of Kentucky court. It didn't go to the court that way. It went to the court, United States District Court. There's only one, right? United States is a district, has one court. This office happens to be in Denver, Colorado, but, it's just one court. Sent a one-page complaint, right? Based on the very first page and whatever they send you. What's the name of the court? It's going to be wrong. What's the name of the plaintiff? It's not going to exist. What's the name of the defendant? They're not using legal names. What's the name of the attorney? He's not using his legal name. Hey, this can't be legal because the full legal name has been defined by Congress in 6 CFR 37.3. So, you could use this, I think, for any kind of court case because it has nothing to do with what they're saying that you did. It's everything about what they're doing. They're committing a crime. Forget what they said you did. Point out their crime. Okay, so let me regroup here and make sure I got all these. We've done all these things. Yeah. Okay, so let me reload with some other tidbits of information. Hang on. Okay, so this is out of the Federal Rules of Civil Procedure, Rule 3. A civil action is commenced by filing a complaint with the court. And I believe that's what we've done because, hey, we got a court case number, right? So what did we do? Well, we filed a complaint with the court and commenced a civil action. Well, I really wanted it to be a criminal action because I want them arrested. I'm trying to get an arrest warrant issued for offenses against the United States, which is under 18 U.S.C., United States Code 3041, Powers of Courts and Magistrates. For any offense against the United States, the offender may, by any justice or judge of the United States, or by any United States magistrate judge, or by any chancellor, judge, or supreme of a supreme or superior court, chief or first judge of the common pleas, mayor of a city, mayor of a city, mayor of a city, justice of the peace, or other magistrate, or any or of any state where the offender may be found, and at the expense of the United States, be arrested and imprisoned or released as provided in Chapter 207 of this title, as the case may be, for trial before such court of the United States as by law has cognizance of the offense. Copies of the process shall be returned as speedily as may be into the office of clerk of such court, together with recognizance of witnesses for their appearances to testify in the case. A United States judge or magistrate judge shall proceed under this section according to the rules promulgated by the Supreme Court of the United States. Any state judge, magistrate acting hereunder may proceed according to the usual mode of procedure of his state, but his acts and orders shall have no effect beyond determining, pursuant to the provisions of some section, whether to detain or conditionally release the prisoner to trial or to discharge him from arrest. Yada, yada, yada. So, they want to have him arrested for offenses against the United States. Well, that would take a criminal action. So, in the Federal Criminal Code, right, now again, this is Rule 3, complaint, compared to Rule 3, commencing an action, which says to file a complaint. Right, this is civil, this is criminal. Criminal says a complaint is a written statement of the essential facts constituting the offense charged. Except as provided in 4.1, it must be made under oath before a magistrate judge, or if none is reasonably available, before a state or local judicial officer. So the only difference between this complaint for a federal or for a criminal complaint and this one for a civil action, which isn't a criminal complaint, is that you need to swear to it. Must be made under oath before a magistrate judge. except as provided in Rule 4.1. So, hey, Rule 4 talks about how they do the arrest warrant. We'll read that some other time. What about 4.1? A magistrate judge may consider information communicated by telephone or other reliable electronic means when reviewing a complaint or deciding whether to issue a warrant or summons. In other words, call the judge. Say, hey, you have my case number, yada, yada, yada. I want to swear to my complaint. What do we need to do? I think by Rule 4.1, you can just do it over the phone. I want you to issue arrest warrants. I didn't mean it to be civil. I meant it to be criminal. Taking testimony under oath. The judge must place under oath and may examine the applicant or any person on whose testimony the application is based. Fine with me. Yeah, they can do it over the phone. I've had who did it? TIGTA, Treasury Inspector General for taxes, I think it was. Special agent called me because I had put a complaint in, and they put me under oath over the phone. And she may have even said, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? That may have been the oath. And I said, I swore to everything I believe. Right? She can say what she wants, but I said what I want. Well, I'll swear to everything I believe. You know, that way you're not swearing to everything, just what you believe. I believe it to be true. If I'm wrong, well, I made a mistake. Anyways, we're going to give them probable cause. That's all we need to do is give them probable cause. And that was hopefully what the complaint was, to show, hey, they're not using their name. Right? You can go read it yourself, and their rules are supposed to be registered on the, this is for the attorney now, right, with the Supreme Court on a roll of attorneys. They're certainly not using the defendant's name. And. So that's really the only difference, right? And why? I'm going to try to get it from where we are now, because they've opened the case. I mean, this part's been done. Civilly, a civil action is commenced by filing a complaint with the court. Well, we filed a complaint with the court, and they opened the court case. And it's a CV court case. And the only difference between that and criminal is the fact that it hasn't been sworn to yet. But it's the same complaint. Just need to swear to it to the magistrate judge, and you can do that over the telephone. Ain't that wonderful? Okay, and we're going to find out when we go look at the stuff from PACER that they have determined this to be federal question jurisdiction. So it's not, what's the other one? Diversity, where it has to do with money. It's federal question, which doesn't have to have anything to do with money. Money are damages, and those can only be given by courts of law. Or it's the only remedy a court of law can give is a money damage. Well, we don't want that. We want equity. Federal question jurisdiction gives the court jurisdiction and equity. So, in the United States law, federal question jurisdiction is subject matter jurisdiction of the United States federal courts to hear civil case because a plaintiff has alleged a violation of the United States Constitution, federal law, or a treaty to which the United States is a party. We did. Article 3 of the United States Constitution permits federal courts to hear such cases so long as the United States Congress has passed a statute to that effect. However, when Congress passed the Judiciary Act, which authorized the newly created federal courts to hear such cases, it initially chose not to allow lower federal courts to possess federal question jurisdiction, for fear that it would make the courts too powerful. The Federalists briefly created such jurisdiction in the Judiciary Act 1801, but was repealed the following year, not restored to 1875. The statute is now found at 28 U.S.C. 1331. The district court shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. You make it offense against the United States. That's how you get it into Article 3. Right? You're the ex-rel plaintiff. But you're not the injured party by law. The injured party by law was The United States. So the United States attorney should be the one that's going to prosecute it. Unlike diversity jurisdiction, which is based on the parties coming from different states, federal question jurisdiction no longer has any amount of in controversy requirement. How those two go together, I don't really understand, but they're convoluting the story here. Unlike diversity jurisdiction, which is based on parties from different states, right? Well, that isn't what we have. We're from the same state. We're from the United States, right? All this is in the United States. The United States is a state, right? It's one nation under God, indivisible, with liberty and justice for all. But federal question jurisdiction no longer has any amount in controversy requirement. It doesn't have to have a dollar amount. You don't have to be looking for damages. You could be looking for equity. To meet the requirement of a case arising under federal law, the federal question must appear on the face of the plaintiff's complaint. There has been considerable dispute over what constitutes federal question in these circumstances. But it is now settled law that the plaintiff cannot seek the jurisdiction of the federal court merely because it anticipates the defendant is going to raise defense based on the Constitution. Well, no, that's not what we're using it for. We're going to say he violated the Constitution. The defendant's not going to use it as a defense. The prosecution is going to use it as a hammer and drive the defendant like a tent peg for violating the laws of the United States. This well-pleaded complaint rule has been criticized by legal scholars, but Congress has so far chosen not to change the law, although the Supreme Court has made clear it is free to do so. Jeepers, they wanted to make it difficult to use, right? They're trying to hide the remedy. But there had to be one. Has to be one. We're going to go find it. Okay. Hang on again. Okay, so this is the PACER website, right? And hey, you can go here and register, and you can look up court cases. And find a case. You can do it by the court links. You can do it by PACER case locator. Search the PACER case locator now. Hey, I'm in. You know why? Well, because I have a freaking account. No, I didn't want to do it that way. How would I was going to do this? Hey, let's do it by parties. Let's find a party. Because I knew the name. Topa. Wow, look at all these topas. I had to have done it a different way. But as you can see, hey, you can find all these cases. Right? All this is, public record. There it is. Anyways, it's a little bit hard to follow on this, so I did some screen prints. And when I found the case, I'll make this bigger. View zoom. There we go. Like the first page you'll find is this page here, where there's a court case 118CV00536 GPG TOPA versus no named defendant. So there's no named defendant. Now, why is that? I'm not really sure yet, but I do know that if it was being done ex rel qui tam prosecution, that they wouldn't necessarily have a defendant because the case would be sealed. But it's been given to a presiding magistrate. And then you have all these choices, right? So I just went through and I did, okay, well, what are these? Here was one for aliases. There are no parties with aliases for this case. Okay. Associated cases. There are no associated cases for this case. Now, maybe that will change. Maybe we'll go from a CV to whatever criminal is, CR, I think it is. Maybe we'll name a defendant. Sorry, no attorneys found so far. Well, that bothers me. I want the United States Attorney to represent the United States, and the current plaintiff to be the XREL plaintiff. What is this here? Case file locator. There's the number. Volume CS1. Case title. TOPA versus no named defendant. This case file may be available, whatever that means. Case file location. Case summary. All right, all this stuff stays the same. Office is Denver, when it was filed, no jury, nature of suit, 440, right? So if you Google nature of suit 440, it's got some definition. Cause, 28, 1983, civil rights. I'm not really sure how that goes together, because it would be 42 USC 1983 for civil rights. I'm not sure where the 28 came from. But, they do. I mean, that means something to them. Jurisdiction says it's federal question, right? Now, this is the federal court saying it's federal question jurisdiction. They've made the determination. County, Jefferson. Origin 1, defendant custody status. We don't have one yet. Got some flags. Plaintiff, right? Helena, Malgortskia, Topa. That would be her full legal name. And we don't have no named defendant. I'm not really sure where that is. We read what the complaint was. We said who it was against. But maybe we didn't say specifically enough, or maybe the case is sealed. Deadlines. There are no deadlines. Hearing events for this case. Civil docket for this case. Topa versus Mr. No Named. It's who it's been assigned to, the cause, the jurisdiction. And that all reads about the same. The plaintiff, right? Now it says she's represented pro se. Now look at how they did her address. This is what you need to look at, Helena. They put your pound 2.207 on a second line, right? There's two lines. You got the first line of the address and the second line. And they didn't put it here as part of the first. They put it as the second. I don't know if that will affect if you're going to get mail or not, but you need to find out if they got your address right so that you get the mail, because they should be mailing you stuff. You got a court case. And then what was there? This had to do with items that had been filed. I guess I cut the top off. Or maybe it was part of this one. I think it's part of this. Civil docket for the case. That's the first part. And this is the second part. And it shows date filed. Document text. Letter. So they called it a letter. I guess I wish they would have called it an information. So maybe next time we'll be a little more clear. Official business United States. Well, that's what we had called it on there, right? RE. So we'll just change that next time and say application for arrest warrant. 2, case assigned to a magistrate judge. Text only entry. Text only entry. What does that mean? Text only entry. Does that mean it's sealed? I don't know. I know that they can seal them. And they do when they're doing qui tam prosecutions. In other words, the United States is the plaintiff already. We just don't know it. But somebody opened a court case. Helena didn't do it. She didn't go down and spend $470. She didn't spend $40-some. She didn't do nothing but mail it. And said, well, what's next? And I said, well, let's just wait and see. And I went to Pacer and looked on the same day that it said it was delivered. And by God, if in the afternoon there wasn't a court case. Apparently, the United States opened up a court case. Filed and entered. Case assigned to the judge and the letter. Parties, still, we got no name defendant. Added 3/6/2018, whatever that means. They're going to have to tell us. And then finally, related transactions, right? You could go down here and, well, nothing's really changed. They're all saying the same thing. Got a letter, court, a case assigned to the judge. Well, I think Helena needs to call the judge's office and say, hey, I have this court case with you, A1-18CV-00536-GPG, that I meant to be criminal, not civil. I believe I need to swear to my complaint. Can you take my oath over the phone and make it criminal? Pending status, STATUSCS. What is that, statutes? I guess so. There are no pending statuses, I guess, records for this case. I don't know what that means. Document section menu. Right? So if you wanted to view them all, hey, you click view them all and pay 70 cents. And because all these things are, 10 cents a page to look at. If you don't do over a certain amount in a quarter, they don't charge you anything. So if you just want to go look at a couple cases, you can open up a Pacer account. And that's what we did. And so, hey, you can all say what you want to say. What I'm going to say is there's a court case. 118-CV-00536-GPG in the United States District Court, Denver, Colorado. And that's the way she rolled. Now, because I want to read the complaint that I put into the Supreme Court in case I can't find it online someday like this. I'm still going to make my record of it. So hang on just a second. Okay, remember earlier I showed in Title 39, it's a section on the private express statute where it talked about a letter being a message and a message being information or intelligence. Well, what is information? And information is a formal criminal charge which begins a criminal proceeding in the courts. The information is one of the oldest common law pleadings, first appearing around the 13th century, and is nearly as old as the better known indictment, with which it always coexisted. Although an information has been abolished in England and Wales and Northern Ireland, it is still used in Canada and the United States, various other common law jurisdictions, because the Fifth Amendment of the United States Constitution especially created a constitutional right to be indicted by a grand jury for information used in federal criminal procedure only when a defendant voluntarily pleads guilty and waives the right to an indictment. Well, they'd have to go and investigate him and see if he'll get him to plead guilty. So, I gave them an information for an information. We'll see what they do with it. Okay, now this is the other case for Arlene Foster, who did the same thing in Detroit, but she didn't just send 4 pieces of paper, she sent, 250. So I can't do all the same things I did with hers here as I did with Helena's. But they did do hers a little bit different because hers is a MC. Now there's only 4 kinds of cases. Case styles, I guess, case types. You've got criminal, civil, magistrate, judge, and MC. Miscellaneous. And this is miscellaneous right now. No parties so far. There are no parties with aliases. There are no associated court cases. Now hers has got a 2, right? The other one had a 1. This got a 2. I don't know what that means yet. This has got two sets of initials. One is a district court judge, MAG, and MKM is magistrate judge. And then Foster. See, that's all part of the court case. They got Foster as part of the court case number. Sorry, no attorneys so far. Case summary. It's in Detroit. Nature of a suit. This is 890. I can make this a little bit bigger. Zoom. Yeah, 890. No cause code entered. Federal question. Wayne. Da-da-da, da-da-da, da-da-da. What does all that mean? I have no idea yet. No parties or corporate parents. No. No deadlines. What was this? Docket sheet for that court case. See? Case number. It's right in there. The case number has her name in it. It says civil docket for the case. Foster assigned to the district judge, referred to a magistrate judge. There's no cause entered yet. This happened on 2/26/2018. So this is some time ago now. Except she didn't know right away. This is the thing. We didn't really know right away because she had lost her tracking number, so we couldn't really track it. And I didn't really understand. Well, I'll just go to Pacer and look for it. And now I do. Okay, so that's why went really quick to the other one to see where they were at. But the 26th was the Monday, and she had mailed it like on maybe the Wednesday before, right? So it got there over the weekend and got put in on Monday. But it says one truth affidavit, where the other one said it was a letter, right? This says it's a truth affidavit. Now, maybe that's why it's an MC, because they're saying it has an affidavit in there. Administrative, in the nature of supplemental rules for administrative and maritime claims made by Yvonne Arlise Foster. That's what she had in the rest of her paperwork, right? I have to assume that has something to do with the 200 pages of stuff she sent, because what we had asked for was an arrest warrant. So they've characterized it the way they want to, and that's okay with me as long as they give her a remedy, right? Right now we're trying to figure out what to do next. Filers. Hey, Yvonne Arlise Foster, right? Full legal name. Not backwards. Not some crazy ass other thing. Just parties. Yvonne Arlise Foster. NRE, right? So this is in the matter of. So it's not a criminal and it's not a civil, which would have plaintiffs. This is a thing in the matter of. And it must be in the matter of her claims that she made. To do with the truth affidavit. And so again, this is a matter of Yvonne just going to have to call up the person that was referred to, magistrate judge, Mona K. Whoever it is, Zub, and find out from her office what she needs to do next. And say, well, really, I was looking to have an arrest warrant issued. Can we, can I swear to my complaint that was in the envelope? Because what we had done, the idea is you put your information letter in the envelope. But you can put your evidence or your exhibits or whatever else in the packet. That's just more information going, right? That's written material. But the letter can go in the envelope. Should go in the envelope. And your exhibits maybe could go extra. Well, so she sent everything that she had done over some period of time, which is quite extensive. I mean, she's done a lot of research, but I don't know that it's going to make it any quicker. It just made it harder for me to pull all the information offline, and that's just the way it goes, right? You learn by doing. This is why we do, to learn, right? And what we learned was There's a docket report. Oh, right. Document number 1 at 110 pages. Anyways, they said there was 229 pages, right? And it's like, well, at 10 cents a page, that's $22.90. I'm just going to have to wait and see what they had to say some other way. I could have done the document confirmation, maybe. Maybe I should have. So that's what she did. And hers was based on what did we base hers on? There's another really short one. Right, there's no need to get to overwrite it. It was going to be something like this. Address, phone, FEIN, CRID, that's your customer registration identification number if you're registered with the post office. I'd put my social security number. But if you got an FEIN, well, it's tied to your social security number anyways. And, you know, if you have an FEIN because you registered your full legal name as a sole proprietorship of which you're the owner in your full legal name, well, then you would have an FEIN, a Federal Employer Identification Number. RE. See, I should have named it this way. Application for arrest warrants for offenses against the United States and equitable relief. I believe that's the way I had it on Helena's, and I changed it at the end. Shame on me. I should have left it just like that, and that's what would have shown up on hers as the reason for us being there. Clerk, take notice. I'm informing you of offenses against the United States for which I ask arrest warrants be issued, and I receive the protection of the United States and a complete remedy and equity. We want equitable relief. By use of false statements and omission of material facts, individuals who falsely assume or pretend to act under the authority of the United States are simulating a legal process under color of law in an improper venue before a private tribunal that has no constitutional authority to adjudicate crimes. I think I said that pretty much the same way in the other one. You might just stop and write those down and say, well, there's a paragraph I can use. Because all that really changes is we're going to have a few basic paragraphs, and then your situation will have its own set of facts that it'll be based on. But it doesn't change what they're doing. Just change the set of facts we're using for this particular, go-around. False accusers conspire against rights, hide their true identity, and value of my one share of the public trust now held under Social Security account number, da-da-da-da-da. I'm putting it in there. I'm just claiming it's mine. Congress defined the full legal name of the Real ID Act in 6 CFR as part of the Real ID Act in 6 CFR 37.3. Hey, we read this before. An individual's first name, middle name, last name without use of initials or nicknames. You see an initial, say, brother, if that's an initial and not your full name, then it's not your legal name. And you got to use your legal name in legal matters. None of my accusers or their judges are using full legal names as identification. They also intentionally concealing my full legal name by using an unregistered legal fiction from official records, charging instruments, complaint information, or the like. Because what they're doing, see, your full legal name is your first name, middle name, last name. They are using your true full name, which is your surname coupled with your given name. Just Google a driver's license, California, and look at the images, and you'll see what I'm talking about. It'll have your last name and then your given name, much like a passport does. Well, those are all King George III's jurisdiction, United States of America. See the Treaty of Peace, 1783, very first paragraph, where he's explaining who's involved. And he says he's the king of the United States, the kingdom known as United States of America. Right? Which is different than the United States of America, which is the Confederation, Republic, created under the Articles of Confederation. The style of the Confederacy shall be the United States of America, where the is a capitalized T part of the proper name of the entity, which is not United States of America, which is King George's kingdom. Anyways, evidence to substantiate my request for arrest warrants is enclosed with this message in the form of alleged legal documents used in the proceeding under the case in the court. Right? So all I really wanted her to use was this and send the frickin' ticket. Right? And in her case, she also had an unsigned felony complaint, right? They had a complaint in, so it was for a felony. It wasn't signed. It wasn't on the state form. It was a simulated legal process. Here, just put these in and send them. But she sent a few more, and, you know, I'm sure it'll all work out fine. I'm just saying, don't send any more than you need to. Right? This isn't about you. This is about them, what they're doing. And what they're doing is they're violating the laws of the United States. The belligerents continue their persecution of myself and offending the laws of the United States, for which I demand you have them arrested and see that my Social Security account is audited, all debts discharged, and balance made available to me in my full legal name. Get it all at one time. Whatever they need to do, right, to say it's yours. I'm not saying that we even should get it. It isn't going to go to your account. It'll stay somewhere, and you'll just get a card, and you run it, and it will work for everything. Right? It's the public trust. You don't have to have it. It can stay in the trust. You just need the parts you need. And we did this way back on 2/19, right? And it was sometime later when she finally got an answer. And then in the meantime, got this answer for Helena. And I had sent one, and it's like, well, I think I'll do a video now, and we'll see where we are. So that was Yvonne's, right? Hers is at the Detroit court. So what did I send to the Chief Justice, right? So, because I want to do my own public record in case I don't ever find it online, because this may not have been the official address. But it is the official business of the United States. Official business of the United States. Information on constitutional crisis obligating the United States to act. Individuals falsely claiming authority under the United States offend the laws of the United States and deprive the people of the United States of rights, moral obligation of the government of the United States to provide relief. That's what this is about. Original jurisdiction of the Supreme Court over offenses against the United States. The judicial powers of the United States shall extend to controversies in which the United States shall be a party, thus invoking the Supreme Court's original jurisdiction in this matter. 18 U.S.C. 3041, powers of courts and magistrates, authorizes magistrates to issue arrest warrants for offenses against the United States, and also justices of the United States. Go ahead, Chief Justice, issue an arrest warrant. Because here's the constitutional crisis. Mr. Chief Justice, the people of the United States are deprived of fundamental services authorized by the Constitution because the President-elect, members of both houses of the United States Congress, and the several state legislatures have failed to comply with Clause 3 of Article 6 of the Constitution, in which it says the senators and representatives before mentioned and members of the several state legislatures and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution, support, but no religious test shall be required as a qualification to any office or public trust under the United States. I can find no official record of the United States that the President or senators or others mentioned in Clause 3 have complied with Statute at Large 1 Stat 23, an act to regulate the time and manner of administering certain oaths, and recited, subscribed, and recorded the Act's oath to support the Constitution. So if you go and Google 1 Stat 23, the oath is in there. It says everything they need to do to comply with Article 6 of the Constitution. They haven't done it. I ask you inquire into the executive and legislative branch compliance, and if none is found, then declare an emergency. Right? Because if they haven't done this, then the president isn't the president. He's still the president-elect. And the members of Congress aren't members of Congress. They're members of Congress elect. Actually, they're not, because they were never properly elected in their own state. Right? Because they didn't run in their full legal name. They don't have a certificate of election. I mean, there's just all sorts of errors. It's just never ending. This defect in the election process is a constitutional crisis that may result in acts of treason. Duh, you think? And is most certainly an offense against the United States, as it makes it impossible to commission officers of the United States in accordance with Section 3 of Article 2 of the Constitution. Right? This is the president now. Article 3, or Article 2, Section 3, states that the president has to commission all officers of the United States. Well, he can't do it unless he's the president. He's not the president unless he's complied with statute at large 1 Stat 23. So where's the certificate? Offices necessary for good governance are vacated, and it appears that there is no commissioned judicial or executive officers of the United States or the several states to enforce the laws of the United States. It is clear from Marbury versus Madison that no commission equals no authority. Which is what Marbury and Madison's really all about. Forget the other shit they say it is. No, if you don't have a commission, you don't have no authority. That's what it's about. As an example, the United States Postal Service Board of Governors does not have any members appointed in accordance with Title 39 United States Code. This defect denies the people a basic and fundamental service authorized by the Constitution and undermines the legitimacy of this instrumentality of interstate commerce. Post offices no longer cancel postage stamps to inhibit people from obligating the United States. That would be 18 U.S.C. 008. Right? You obligate the United States by canceling a postage stamp. Now they're a party to the contract. There's other things that do it too, but that's one of them. In accordance with 39 U.S.C. 101 Postal Policy, the United States Postal Service shall be operated as a basic and fundamental service provided to the people by the government of the United States, authorized by Constitution, created by acts of Congress, and supported by the people. It's not a frickin' private company. No, it's an agency of the government. This basic and fundamental service shall be directed by the Board of Governors, 9 of which shall be appointed by the President, by and with the advice and consent of the Senate. That'd be in 39 U.S.C. 202, Board of Governors. Currently, all 9 commission seats are vacant, leaving the board unable to form a quorum for the business of the United States Postal Service to provide basic and fundamental services. 39 U.S.C. 205 says procedures of the Board of Governors. In C, the board shall act upon majority vote of those members who are present, and any 6 members present shall constitute a quorum for the transaction of business by the board. The United States Postal Service, established by postal policy and operated as a basic and fundamental service provided to the people by the United States, or by the government of the United States, is unable to fulfill its constitutional mandate, thus obligating the government of the United States to remedy the injustice. Identification theft, human trafficking by federal and state agencies. The United States is further obligated, as its agency are used by usurping evildoers to perform acts of terror, trafficking in human beings, extortion, and embezzlement upon the people of the United States, persons, and wealth. As an example, 6 CFR 37.3 defines an individual's full legal name as an individual's first name, middle names, and last name or surname without use of initials or nicknames for purposes of identification. However, the Social Security Administration, in its Program Operation Manual Systems POMS RM 10212.001, defining the legal name for an SSN, has unjustly determined to use an unauthorized definition for an individual's legal name. And you'd have to go read that. Just Google defining the legal name for a SSN, and you'll get to it. And it says in there they use your first name and last name. They don't use your middle name. Well, Congress has already said, no, your full legal name is your first name, middle name, last name. Well, then who the fuck is Social Security to say, no, we're going to do it this way? No, that would be a crime. That would be depriving me of rights. It's contrary to the Real ID Act and clouding the owner's title. The Social Security Administration is concealing full legal names, as defined by Congress, from the official record of ownership of Social Security accounts, as well as concealing the owner's physical address in the United States. For the record, I, Robert Allen Ratluski, reside in the United States. I am the owner of Social Security account 374506794, and I demand its full accounting, discharge of all debts, liens, or other encumbrances, and the release of its value to myself for my own use and enjoyment. I just need the value. Further, evildoers usurping authority, usurping authority under the United States conspire against rights by using unregistered legal fictions as the identification of the parties to contracts and legal proceedings, resulting in simulated legal processes that deprive people of rights under color of law. These usurpers have gone as far as claiming the nation is governed under the Noahide laws. Can you believe that? The president actually signed a law, joint resolution, 105 Stat 44, Public Law 10214, March 20th, 1991, within which it says, hey, we're under the Noahide laws. Which means, well, then we're not under the Constitution. I believe that's incorrect. These usurpers have gone as far as claiming the nation is governed under the Noahide laws and not the Constitution. For the record, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. My nation is under God, not Noah. The people of the United States are not secure in their persons, houses, papers, and effects from unreasonable searches and seizures of agents of the United States of America. King George III's successors are rebelling against the Constitution, and the government of the United States is obligated to provide relief to the people of the United States from these belligerents. Mr. Chief Justice, I have provided you probable cause to issue, and should have been for issuance, to issue arrest warrants and orders to the United States Armed Forces to quash the ongoing rebellion in the United States. I order you in the holy name of Jesus of Nazareth to execute the authority of your office. Amen. In the name of the Father, and of the Son, and of the Holy Spirit. God's watching, Mr. Chief Justice. I state under penalty of perjury that the foregoing is true and correct. Executed 2/28/2018. Okay, so I sent that, and well, as of yesterday, I couldn't tell I had made it to the Supreme Court yet. But I'm trying to get them in their original jurisdiction, so it wouldn't be as an appeals case, right? It would be, well, it would be to whatever that means, the Chief Justice of the Supreme Court. And now, having done this, and having seen how the other ones worked, I'm going to, tweak it a bit and say, okay, I'm going to see if I can get the official business addresses to places by doing a FOIA to the post office and getting them out of the mail manual, which I'll show you real quick. Let's just go look at that, and then we'll call it a day. Post office, official mail. Handbook, DM 103, official mail, February 1998. And all the way at the end, they got this appendix. Right? Places that agency authorization codes. Right? Here's our agency code. Well, to have this code to be able to send mail, then they had to have supplied the official return mail address. So like the Administrative Office of the United States Courts is in here. and all sorts of things, right? Eventually we'll find the district courts of the United States are in here. All right, district courts. They got one. Hey, they got the same one. It's number 9. The Supreme Court. Right, there's Treasury. All these places, they all have an official mail address. They all have an official business address because they've gotten themselves an official mail permit. Right, and the way to get these would be, there's the Supreme Court of the United States, 204. Right, so the way to get these would be, well, I guess to do a FOIA to the post office and say in your handbook, DM 103 official mail, Appendix A, there's a list of agencies that have mailing permits, and you want to have the return, the official business address for those entities. And see what they'll send them to us. That's the plan. Okay, hey, I think that's enough. That's what's going on, right? We've got it as far now. Is this thing still going? Yeah, I'm still talking. Yeah. We've gotten it as far now as being a civil case in a district court, in the United States District Court. It didn't cost any money. So it means the United States must have opened it because we didn't pay for it. But there's a court case. So who can open a court case without paying for it besides the government? And I'm sure I've read it before. I just didn't go find the thing today, but I'll go find it. I'm sure that that's the case. That, outside of the United States, I don't know who else can open a federal court case without paying for it. Now, unless they're going to send a bill to these ladies, we'll see what comes in the mail. I don't know. We'll see what they do with yours. So go do it and see what happens, right? Send it in a priority mail envelope. I just look at that one more time. I guess that's important enough that I do want to look at that one more time too. So where was that? Right? This is how I would do it. Rotate clockwise, right? I would do it in an envelope like this. And that envelope would go inside of a priority mail envelope like this. And the only thing that I might add that isn't on here, but I think it's included when you include insurance, which I did do, is that they have to sign for it. Right? So somebody had to sign for this. Otherwise, you can get delivery signature verification, right? You don't want certified mail. You don't want that green shit. You don't want nothing to do with that. This is priority mail, and they have just a thing for delivery confirmation or something like that. Right? Delivery signature confirmation is $2.50. But I do believe if you put insurance on it, that they have to sign for it. But don't hold me to that. I mean, I do believe that to be true. And so I didn't put the extra thing on there. These other ladies didn't put it on, and it got there just fine, and it opened up court cases. So I don't even know if it's necessary. But that's the idea, right? To get it in there as a complaint to the court so that it gets made into a civil case. And now it is there as a civil case. And the only difference between a civil case and a criminal case is that the person has sworn to the complaint. And maybe that can be done by phone now. So I may have an update for you soon. Okay, y'all have a great day. We'll see you. Bye-bye.